Thank y'all for being here. I think we'll have a few more trickling in. They're finishing some other meetings, but we're going to go ahead and get started. I'm Lauren Bailey. I serve as your General Counsel for the State Medical Society. I'd like to, was that me or y'all? Okay. I'd like to thank our panel members for putting this great program together. They spent a lot of time to educate you guys, and we very much appreciate y'all. First, we have to my far right, Brent Hicks. He's the co-chair of McGlinchey Stafford's Government Contracting and Construction Practice Group. With more than 20 years of experience, he has litigated and arbitrated many business disputes involving non-compete agreements and restrictive covenants in several industries and states. Here to my immediate right, we have Scott Cady of Butler Snow. He has a commercial litigation and commercial transaction practice. Scott concentrates much of his practice on the representation of hospitals, pharmacies, physician groups, and other healthcare providers, and has represented such varied healthcare providers in litigation, provider contractual and operational issues, licensure, fraud and abuse, and other regulatory matters. And in the center, your very own, who seems to be very important up here, is the co-chair of the Louisiana State Medical Society and Louisiana Bar Association Medical Legal Interprofessional Committee, on which he has served since 2000. He's a specialist in physical medicine and rehabilitation. He has certificates of added qualification in pain medicine and spinal cord injury medicine. He has extensive experience in expert witness testimony, independent medical evaluations, medical review panels, medical organization politics, and governmental lobbying. We thank you again for taking your time to speak with us today. Once the panel is finished with their presentation, we will have a question and answer segment. As a reminder, this panel discussion is for information purposes only. It's intended to assist you, our members, in understanding the validity and enforceability of non-compete clauses. We ask that all comments to the panel be submitted in a form of question and that we not name any individual, practice, partnership, corporation, or healthcare system. Thank you.
All right, thank you, Lauren. We can't tell whether to sit down or stand up, so we're going to do a little bit of both. So Brent, Randy, and I, at the outset, want you guys to know that when Lauren called us, we were so excited that she asked us to speak on this particular topic. So we said to ourselves, look, Lauren, we can talk about politics, we could talk about religion, we could talk about the impeachment trial. She said, no, I'm going to have you guys talk about something that's even more divisive. I'm going to have you talk about non-compete clauses with physicians. And I say that in jest, but honestly, I represent a lot of medical practices who say to all the time, we have the right to enforce these, and we want to do it to the full extent that we can do so. I also represent a whole bunch of individual physicians who say, I should not be subject to these, and if I am, they should be very restricted. So, again, kind of in jest, we're not exactly sure how this is going to go here today. But as I tell my boys, when they always ask me, look, Dad, I don't know if I should do this. I don't know if it's going to turn out right or wrong. I always say, what's the worst that can happen, right? And my youngest boy always says, not too much. We got a roof over the head. We got food. We got friends. And my oldest boy always says, the worst that can happen is our house burns down, we lose all our money, and we're kicked out on the street. So we're not here to burn anybody's house down. We see both sides of this argument, okay? Should I call it an argument? Maybe not. Both sides of this issue. Let's talk about that. So what we're here to do is just show you both sides of this and kind of educate you on the law, educate you on what's enforceable, what's not enforceable. But we really are here for you. So we would like you to ask questions. If you guys have questions, I want you to ask Brent because I don't know the answers, okay? Legal questions, medical questions, then I'm going to just sit down, all right? So, okay, you got it. All right, so let me briefly, I'm going to take you through kind of the agenda that we're going to go over. These are the 7 topics that we're going to talk about because I always hate sitting in the audience and listening to somebody when I don't know where we're going, and most importantly, I don't know when it's over, okay? So you're going to be able to figure that out through this. So what we're going to talk about first, we're going to talk about, and there are 2 sides, right? We're going to talk about what the physician's goals are in connection with when they're faced with a non-compete. And we're going to tell you also the other side, what the practices, the medical practice. By medical practice, I certainly mean hospitals, clinics, etc. what their goals are in connection with a non-compete. That's the first thing. Second, we're going to talk about the policy considerations, right? We're going to talk about what the policy considerations for such non-competes are and what the policy considerations against such non-competes are. So you're probably not surprised. The American Medical Association has a policy on this. Louisiana State Board of Medical Examiners has commented on this. And then commentators across the country are they're vehement, one way or the other, right? For or against. So we're going to tell you some of those. Third, Brent is going to tell you, like that, huh? Brent is going to tell you what the law is in Louisiana, right? You need to know what is the actual law on restrictive covenants. And I'm talking about non-competes and non-solicits. And how did that affect physicians? Spoiler alert, they do not carve out physicians. Interestingly, they carve out car salesmen. That's true. It's in the actual statute. You cannot put a non-compete on a car salesman. You can put a non-compete on a physician. Fourth, we're going to tell you about a recent effort to amend the statute, the restrictive covenant statute here in Louisiana, and it actually affected physicians directly. It did not pass, but rest assured, I believe it's going to come back again. Fifth, we're going to tell you about what other states do in connection with non-competes and physicians. It kind of runs the gamut, but we want you to kind of see the trends of what's happening in the nation. And then the last two things we're going to talk about is one, in connection with non-competes overall, not just physicians, but just generally in non-competes in Louisiana, some thoughts that we have as lawyers, some thoughts that we have as physicians, and some things that you need to be thinking about when you're dealing with a non-compete. And then last, we're going to try to, if we get there, we're going to try to show you some actual provisions, some non-compete provisions that courts have considered in connection primarily with physicians in the medical field space. And we're going to ask you to look at it and see, what do you guys think was the issue? What were they fighting over? And was it enforceable or was it not? So we're going to try to put you into the mind of the judiciary here in Louisiana. Good luck with that. This is being filmed, so by that I mean they're very, very smart, and so we're not exactly sure that we can always follow what they're saying. Okay, so those are the things we're going to talk about here today. And as my wife always says, the first thing you need to do is just make sure everybody's on the same page. So what we're going to talk about right here is non-competes and non-solicitation agreements. Okay, so non-compete is just that, right? In the physician space, it's saying that a physician employee cannot compete with a medical practice during the term of their employment and for some period thereafter in a particular geographic location in connection with certain services. And then we probably will also talk a little bit about non-solicitation covenants, which say that a physician during the term of the employment and for some period after separation won't solicit staff. Nobody seems to have a problem with that. Patients, that's where everybody throws stuff. And then referral sources, and that's where we get into some regulatory stuff. But those are the two clauses that we're primarily talking about here in connection with restrictive covenants. So let me briefly talk about the first section, which is the policy, not the policy, rather the goals of both the practice and the goals of the physician in connection with non-compete. So what is a medical practice's goal? And by that I mean, again, hospitals or clinics. What is their goal in connection with trying to put a non-compete out there? Well, I'm going to tell you, when I talk to them, this is what I hear. I hear that they say they want to be protected from competition from physicians in whom they've invested. Now, their concept is this, that I didn't just give you a job, I taught you how to run a business as a physician, okay? In other words, I gave you the keys to my kingdom. I let you see how it is, and I don't want you to use those keys and go open up another kingdom right next to us that competes against my kingdom, okay? I spent a lot of time and effort with you, and then so I should have at least a little bit of time before I get to compete with you. Second, they say, particularly if you're a new physician and if you're coming from another area, they say, I've let you access my patient base, right? You didn't have this patient base. Now you have my patient base. These are my patients, and Lord knows we can talk forever about whose patients they actually are, whether it's who's treating them, whether it's the practice, whether it's the other physicians in the practice. But they say, look, I'm letting you access it. I don't think you should be able to take them right away and go do something else. And third, they always say, I've also invested in my staff. I've also invested in nurses. I've also invested in PAs, right? And so I think that you shouldn't be able to take them right away from me. Now, flip it, right? So what do the physicians say? So you hear all that, This is typical law stuff, right? You hear one side and you go, man, that sounds right. That sounds, I'm with you. I'm all on board. What do physicians say? Well, physicians say, despite what car salesmen are talking about, they say, I am not selling cars. I'm a professional. I've got a personal relationship with this patient. If that patient wants to come with me and doesn't want to stay with you, that patient, who should be the what? The most important thing, right? It's always about the patient. It's always what we can do. It's Hippocratic oath. It's what we're doing. That patient should be able to come with me. And also, I shouldn't have to leave this area to treat that patient. That patient shouldn't have to go somewhere else. And I shouldn't have to leave. I've got my kids at Episcopal, U High, Westdale. We get in a fight about which school is better, right? I always hear that too. But I've made a life here, and I've got things here. My wife and my husband, they have their job here. I don't want to have to leave, and I shouldn't. And my patient shouldn't have to travel very far to get to me. And then finally, the goal of a physician should be this, that to the extent, because it's permissible, it is permissible under Louisiana law, to the extent that I'm under a non-compete, I always tell them, as you can tell, it depends on what side you're on here, but I always tell them we need to look at it. We need to make sure that it's restricted to the extent that it can be restricted, right? That you shouldn't be asked to do things that are not reasonable. And reasonableness is always, it's a lawyer's dream word, right? What's reasonable? What's unreasonable? Well, shoot, you give that to a lawyer. My kid thinks that it's real unreasonable that I make him come in, at midnight for curfew. My wife thinks it should be 10. He thinks it should be 2 or 3. So again, we're in this sort of gray area, but our purpose here today is to tell you kind of how these things go. So that's kind of the first section. You can kind of see from a broad brush what it is that both sides are kind of telling us lawyers what they're trying to do in connection with this. So the second thing, and I may let Brent talk to this, is the actual policy considerations. So in addition to this, there's many organizations and there's many commentators who talk about what's the policy for and against these. So those include what the American Medical Association has said, what the Louisiana State Board of Medical Examiners have said, and just generally we can talk about it. So maybe, Brent, you might talk about the AMA, because he found this ethics opinion, which is exactly on point, and then maybe the whole panel, we can talk about some of these other policy issues. I don't know if you want to sit down or sit. They can probably see you. You're so tall.
Yeah, so there's a code of ethics opinion out there that we have up on the board that provides that the competition among physicians is ethically justifiable when it's based upon factors of service, skill, experience, convenience offered to patients and fees. And if you see there, it says that physicians should not enter into covenants that are unreasonably restrict the right of the physician to practice medicine for a specified period of time or to specified geographic area or termination of a contractual relationship, and do not make reasonable combinations for the choice of the physician. So that is an ethics opinion, and it doesn't say that you can't enter into the restrictive covenants. It just says that they have to be reasonable. So there's a reasonableness quality that physicians need to think about before they enter into these different restrictive covenants. And when we think about the policy considerations, we got to look at both sides. And when you look at the policies, we have the policies that the employer has when they are going to have a tremendous amount of capital that they're going to be investing in the physician, of course, with their sometimes they may have signing bonuses that they pay, training and all of that. So they're going to want to make sure that they recover that, and that's why they are very going to want to have that signing. That they're going to want to have that restrictive covenant there. But so long as it's not unreasonable, you can still do that according to the ethics opinion. And something Scott didn't talk about, there is a distinction that we may want to think about between a primary care physician and a hospital-based physician. When we have a hospital-based physician, a non-compete clause, its use may be more justifiable, if you will, as opposed to a primary-based position. And here's what my thought process on that is. Well, where you have a hospital-based physician, without a non-compete, it could be very easy for that hospital-based physician to get lured by the place where he goes and works every day, the hospital, as opposed to the primary-based physician who there he has the relationship with his patients, and you may not need that non-compete so much. So there may be some distinctions and different reasons for the non-compete. So you have these different policies based upon the type of physician that you have. So we have these different policies that are out there depending upon the type of physician you have. So those are different things that you weigh when you think about non-competes, at least I do.
Right, and I didn't know, Randy, if you had. I did think it was interesting that AMA goes out of its way to say at the very end, but they say physicians in training should not be asked to sign covenants not to compete as a condition of entry into any residency or fellowship program. And I personally feel like that should be sort of a universal idea, but I don't know. Obviously, you probably have a better read on that.
Well, yeah, I mean, being involved in the medical schools and in the residency programs in Louisiana, I often think about that because I think the schools invest more resources than anyone, and ironically, they're the ones who are not insisting upon restrictive covenants with their mentees. And working with residents, I just asked a few for their thoughts, and I got oodles of information and opinions. And I was not entirely surprised to see that they really fully understand these. They're very well aware of them. And they feel that they're at an extreme disadvantage, and that many of these restrictive covenants are aimed towards the people who are just leaving training, who have low salaries, low income, huge amounts of debt, and are very vulnerable. And if they want to stay in a community, are forced to sign these agreements. I thought I'll give you just one comment from a resident so you can see from their perspective what this is about. And working as I do, devoting what most of my professional life to educating physicians for Louisiana, I naturally would like them to stay here. And some of I think we lose some because of these restrictive covenants. This resident said, I first want to acknowledge that I understand the importance of these agreements and why they exist. I understand that healthcare institutions need to protect their own interests and assets. After all, they provide guidance, mentorship, patient referrals, and other resources to aid physicians in building their practice and establishing a patient base. If those physicians used those resources and then moved across the street, stealing that patient base and creating direct competition, then the healthcare institution would have effectively wasted those resources without gaining any return. However, I feel the original intent of these non-compete agreements has shifted to a more malicious objective. Initially, they were intended to prevent that previously described scenario, a failed investment, but now they serve to trap physicians as revenue-producing workhorses with limited options for career flexibility and development. And then he goes on to talk about how he fears being forced to make certain medical decisions based on the institutional preferences because of financial issues. And if he disagrees with that, ethically, professionally, he's trapped, particularly if he'd like to stay in Louisiana, which has the highest native-born population of any state in the country. So, I think it's an issue that certainly deserves exploring, and I guess we're going to talk about policy concerns later.
So let me just say, I think that's interesting. That's a lot closer to what I hear. I'm trying to kind of vanilla it down, right? But that's exactly what I hear from brand new physicians. And I give a talk to Ochsner residents every year about physician employment contracts. And I tell them, look, one of the slides we have, which now we have a lot more slides, which is good with this, is non-competes, because they know about it. They're aware of it. But if I could, here's the issue. It strikes me as unbelievable that car salesmen are excluded from restrictive covenants, but physicians who treat people, who treat humans, are not, at least there's not some kind of understanding one way or another about how we're going to do it. Again, I fully agree that you need non-competes as a business, because here's the other thing. Here's the other flip of it. When I represent medical practices, is you can't survive if you don't make money. And yes, the idea is that we're going to take care of this patient, right? But if we're going to take care of this patient and everybody competes to such an extent that everybody goes under, nobody's treating the patients, right? It's hard to treat a patient as a business. I guess that's what I'm trying to get to. At the end of the day, what we're worried about, right, is patients. We're worried about, yes, they should have the right to do it. On the other hand, if we let everybody compete at the lowest price, we treat it like a Walmart. If we're going to, at lowest price gets it, then we're not going to have anybody left, right? We're going to have poor care. So I honestly see both sides of it. The AMA has kind of given you their position. The Louisiana Board of Medical Examiners hasn't really stated a formal policy, but one of the things they said is they issued an opinion letter, and it said this. It said that we really don't have any authority over the regulation of this. It's statutorily permissible if structured appropriately. And that's just recognizing a reality. It is permissible here in Louisiana. Any changes would require action by the Louisiana legislature, and we'll talk about that in a minute. There was a bill that was out there, and there probably will be more bills in connection with this. But again, they recognize what? The patient. We are concerned if a non-compete disrupts continuity of care, provision of quality care. So with all that, we probably need to wrap up the policy considerations, but let me, if I can find my reading glasses, let me say that the policies for and against that I hear on both sides. So the policies for these non-competes are that, again, the employer invested time, training, and money, and should be able to protect its business from an employee that's competing with the same model. Further, protection of patient base, which again, I know it's not a commodity, but it is the fact that it is a business and they need to make money. And then I often hear this. I say, why should we invest as a practice or a hospital? Why should we invest in new equipment, try to find the best physicians we can, give them the best training we can, if as soon as they get to the point where they can go compete with me, they do? It's a lose. It's what you just heard in this comment. I'm investing money, and then they're getting the benefit of it, and then they get to go out there and do this. And then finally, a lot of people say, look, the legislatures authorize it. It is what it is. It's the law. And that is true across the country. Primarily, most states allow this to happen in connection with physicians. Against, I think we've talked about some of this, is personal fiduciary duty or relationship. They're giving me confidential information. They're trusting me. If they don't like me, they'll go to somebody else in your practice and stay with your practice. But if they're coming with me, then that's because I have this special relationship, like lawyer-client, like clergy-parishioner, that type of thing. Again, patient choice is big, right? So if you enforce this and you have to move to Homa to practice, then the patient has to go to Homa if they want to come to. So I'd often hear, if that patient wants to stay with me, it's unfair that Miss Maggie has to travel way out of this area in order to be able to do this. Again, no one should be deprived of making a living. So it's kind of like you've invested in me, but on the other hand, what I've done is spent a lot of time spending money, debt, many years in training. I should be able to practice, and I should be able to practice in the community that I want to. And kind of to Brent's point, sometimes what happens, there's a few courts across the country that say this. Look, if you're in a specialty area, it's kind of the flip of what Brent said. If you're in a specialty area and there's not many specialists in this community, you can't non-compete them because the community needs them. There's not enough of them here, which is a real interesting situation, right? So court has to go to the extent, say, we can enforce this, but in this particular case, from a pure fairness, a pure, patient-based mentality, we're going to let that person stay here. And then, of course, people always say it's the American way, right? If we have competition, we increase quality and we decrease price. But I've just told you the opposite of that, right? If I invest a whole bunch in you and then you walk away, I'm going to stop investing because it doesn't benefit me. All right, so moving on to the
Well, let
Okay,
me just
go ahead.
respond to something.
Sure.
You made the comment about automobile salesmen and that by allowing competition, it's going to may decrease price. But I'm not sure that that's what would happen, especially when we're talking about the hospital-based physicians. Allowing these systems to get bigger and taking more hospital-based physicians and employ them directly may not decrease price. That may increase price. I just don't know that that's the case, and I don't know that that's necessarily the answer. I mean, that's the other side of the coin that we really need to consider when we're looking at hospital-based physicians. And there may be a good reason, not just for those particular groups to keep it there, but also for the public and for public policy to keep those prices in check. So it may not, in fact, be good for the public to have those non-competes removed in that aspect of the medical field. That's the other side of the field.
And I would like to bring two other points, one of which I heard in almost every resident comment, and that's that there is this argument about protecting an investment. But after a relatively short period of time, that what the phenomenon that occurs is the entity with the non-compete who has created the non-compete agreement can insist on way lower salaries than what the market would provide, and the physician has no option to attempt to seek what would be considered fair and equitable in the community. And that is probably one of the biggest fears that I hear from physicians. And then two, with no regulation of this practice, when we talk about investing in people, I can say from my own personal experience, I was in private practice for many years, and I was associated with a large institution. And I'm older, so I had started without a non-compete agreement. And the physician executive of the organization approached me with a new contract. We make all of our physicians sign these now. It wasn't about protecting investment in me. I was there for years. I was the one who was bringing the patients to the community to see me, and then they wanted me to sign that. I told the doctor that I found it very unprofessional and I wasn't going to sign it, and he was much older than me. He said it was outrageous that I spoke with him in that fashion. And I said, well, did you sign a non-compete agreement? And he said, no, I never did that. And I've yet to sign a non-compete agreement myself. But I see this pervasive thing, and so in many cases, I think hospitals are not protecting an investment. They're just assuring that they can capture physician talent.
Okay, so I think you can see. Yes. Yes, at any time.
My name's Carl Hanson. I'm a direct primary care family medicine physician in Kenner. When we're talking about this investment, when we're talking about the investment, a green light. If we're talking about this investment and then we're just moving on, well, we need to challenge the concept that the hospital is investing in anybody. The investment is at medical school. You're paying the medical school inflated confiscatory sums of tuition to get your medical education. Then you're working at a residency. Certainly you're getting paid at a residency, but the dollars on the hour are at times, at least in my day, indentured servitude. So the concept that the hospital is doing an investment, I think we have to challenge that before we keep using this term. I feel the investment that what the physician has is the training and the experience. When you sign a contract with a hospital, You're getting payment for services rendered. They are not teaching you about medicine. Trust me, a hospital does not teach you about medicine. Now, they may provide staff as part of their contract because they have to fulfill various insurance agreements as far as what kind of services they could provide. But I think we need to stop talking and accepting the notion that the employer is actually investing in the physician. The physician has intellectual property through their training and experience. The second item, especially with race primary care, so I'm a family medicine physician, as I said, if I leave employment, and I'm in solo practice, so it doesn't apply to me, but if I leave practice and work outside my employer, and there's a non-compete enforced, and one of the reasons is that because of competition. Well, that's a fallacy because in any document or study you read, there is a primary care physician shortage in the United States. So for the hospital to make the claim that that is interfering with competition doesn't hold water. So I think the whole investment concept and the competition concept just really needs to be challenged before we move on. That's all. Thank you.
I can't really tell where you stand on this issue. I'm trying to figure that out. I can't do it. I hope that you get out of this, and I think you can hear it, that there certainly are two sides to it. I'll tell you what I hear from hospitals. I'll tell you what I hear from, and I primarily represent physicians, but as I told Lauren, I'll push back the curtains. I deal with both sides. You know what that medical practice is going to say? You know what that hospital is going to say? Go open your own practice. It's America. If you don't think that we're investing in you, you don't think that we're providing something here, then go do it on your own. We're not forcing you to stay with us. If you stay with us, then we want you to sign this non-compete because we don't want to teach you something. Whether and I understand. And the other problem we probably have here, right, is that we're kind of broad brushing, and we're talking about what's an employed physician at a hospital versus an employed physician at a practice versus a small practice versus a large practice. And I think I did bring up, and maybe I apologize if I didn't make it clear, I do think across the country people understand, and I shouldn't have said it as specialists or versus, if there is a shortage in a physician group, and you can show that, I do think, despite the fact that there's not this carve out in restrictive covenant statutes, as I call them, that permit them across the country, there are a lot of courts that say, look, I don't care. I really don't care what's happening. We're not dealing with cards. We're dealing with patients, and if we can't get enough general practitioners, and you can show me, you can prove that to me, which sometimes there's proof and sometimes there's not, then we're going to do it. So I think everything you say is valid. What's funny about this is no matter what anybody comes up here and says, I've probably heard it and I agree with it on both sides. But we're just trying to kind of, so maybe that's a good segue into what can you actually do, what can't you do, right? So the current state of the law, you want to talk about that?
So, believe it or not, under Louisiana law, non-compete clauses are null and void unless they meet certain requirements, and there's an exception to that law. But generally, they're null and void. And there is the exception, though, you could drive a truck through it. And part of driving the truck through it is what we're talking about today, which is it allows physicians to be a part of that. And our law is found in Revised Statute 23-921, and you have to your clause has to strictly comply with these rules, and we have it up on the screen what it has to have. But in general, what you have to have in your clause are the parishes which you're going to have to, which you can't practice in, and the time period, and you can't be over 2 years. So if you have a clause in your contract, it should be very specific as to the area, and it's generally the parish, municipality in the area, or parts thereof, as the statute says. So you ought to have a very specific area and a very specific time period after you leave. So That is what the rule is in Louisiana, and it's been litigated in case after case. And it also needs to talk about, yeah, go ahead. And it also needs to specifically say what your practice area is. If it says the practice of medicine, courts have said that's too broad. It needs to say what the specialty is. Yes, sir, go ahead.
I just want to, I'm George Ellis from New Orleans. I just want to clarify, this says location, but it doesn't say other employer. Is that correct? Restricted from going to a different institution or a different employer.
Absolutely. If you can't, that's the whole point of the clause. You can't go to another employer and compete, but do the same
But
thing.
if they don't specify, this says by region, correct? By parish, municipality, or parts thereof.
Right?
So if all they're saying is you can't leave this institution and go practice at that institution without specifying the geographic region, then that doesn't hold water.
Yeah,
I'm
you
not
specify
following.
the geographic region. If you say, if it's, you can't practice in East Baton Rouge Parish, you can't go from one healthcare system to another within that parish.
Within that parish, but many of our larger employers are in multiple parishes.
And that's what I'm seeing now, which is sort of crazy with the residents, because they're getting contracts that say you cannot practice in New Orleans, Lafayette, Baton Rouge, because we're located in all of those places.
So the
And they
reason
can
I
do
asked
that.
this question is I'm familiar with a recent or soon-to-be finished
You soon it's
trainee.
going to be the entire world.
So a recent or soon-to-be finished trainee is signing with one big institution in the southeastern Louisiana region and is prohibited from leaving that institution and going to another large institution in the southeast Louisiana region. But it doesn't say southeast Louisiana region. It doesn't say parish or geographic area. So it
It's
doesn't
not-
sound like that meets the letter of the law.
Without looking at it, it's going to need to say what area of the state.
I
Probably
can't.
going to have problems.
And maybe this can help you as well, right? So what does it say? It says parishes, municipalities, or parts thereof. So if you're in New York City, it may be a much smaller area. I know we're in Louisiana, but that's my point. It parishes. There are certain circuits, you love this in Louisiana. There are certain circuits that say you have to specify the exact parishes. And there are certain circuits that say if it's identifiable by the context, you can identify what they are, then we will allow those certain parishes not to have non-competes, which is against what the rule is. You brought up a whole bunch of stuff, but the rule in Louisiana generally is that you can strike unenforceable parts, but you can't rewrite them. And so, in other words, if you write 64 parishes down and you're actually only practicing in 32 of them, courts should be able to strike Jefferson Parish, Calcasieu Parish, etc. But if you say Southeast Louisiana, they shouldn't be able to write in what those parishes are. So that's the general rule, but we're dealing with, humans on the bench in state court in Louisiana, and they come up with a whole host of things. But the other point I wanted to make is as to your point about these broad systems. Let me tell you what happened. So you have a huge system that has a whole bunch of these, they practice everywhere, right? And they say, anywhere we practice. Some courts say that's fine anywhere we practice. Some courts say you have to say what it is. But what happens if they want to go to another big system? That system sometimes will say we'll take the heat. In other words, you come work for us and we'll fight the lawsuit. We'll do whatever whatever we have to do. And I think the courts overall are starting to realize that there's so much consolidation in the medical field now that we can't just allow the biggest, you go to work for them once and you got to then leave the U.S. to your point. You can't do that. So I think you're going to start seeing some difference in what the legislatures do on that and what the courts do.
So maybe I could simplify my question. Is it necessary for the non-compete contract, the restrictive covenant, to specify a geographic area?
Yes.
I have never, everyone I've seen has always specifies the city and the parishes like this, very specifically like the statute says. And I think they brought up a point that I've heard many physicians and residents state is these are all very complex legal arguments that are very interesting in this conference. But if you're a physician uh, fighting a large institution for a law that you know is invalid, the cost to do that would probably be greater than the penalty you would pay for the non-compete.
This is a perfect time for me to step in because I tell this to all the residents at Oxford, and I say, look, exactly what you're saying, because and I fair warning, I represent health systems. I represent, so I'm on both sides of it. But if you wait, that's one of the factors we're going to have here is read your contract, right? And I'm talking about even to the health system. Sometimes they put out non-competes that are completely unenforceable, and I'm on the physician side, and you know what I do with those? I'm good, because I know if you ever try to enforce it, I'm going to break it. They don't read them, and neither do the residents, because they want to sign the contract, because they want a job. And I say, look, you come to me before that, or you just Google it. You don't have to come to me. Google it. You can Google and figure out, look, there's certain things in Louisiana you can do or you can't do. But if you wait, the one thing you can't do is come to me later and say, man, I got to leave Baton Rouge. I've got my family here and I got to do it. I always tell them, no, look, let's do it at the beginning. You read it for 5 minutes, right? 5 minutes of your time. And you'll either say, I hate this. This is terrible. But I want to do it because my family needs me to get this job. Do it. It's your thing. Or you read it and you go, man, I love this. I would have been more restricted than this. You go home happy, right? But don't come later, because you're right. Once you get in a fight with somebody, any litigation where you have more power in money and resources on one side, it's going to be impossible. It's going to be very difficult for you to fight it. So I think that's a good point.
And we just went on to the next slide, and the statute makes it applicable to corporations. So regardless of whether it's an employee or a corporation, and then go on to the next slide. It applies to partnerships and then also to LLC. So regardless of what type of entity we're dealing with, it's going to have the same applicability. So whether you're a member of an LLC, whether or not you're a shareholder of a corporation, if you enter into these agreements, it's going to be enforceable against you. There's also damages that if you actually cause damage to your prior employer, they're entitled to get damages. They're also entitled to get an injunction against you without proving irreparable injury. And that in the legal world is a big deal, because what that means is as soon as they know you're out there competing, without them even having to show that you have caused them any damage, without them showing that you've taken any of their customers, they can stop you from doing it immediately. So they put you out of business. Normally for an injunction, you have to show that they damaged you in some kind of way, but they don't have to do that. So they can just immediately go in and stop you if you have an enforceable agreement, and that's what the statute allows them to do. So that is the current state of the law in Louisiana. If you have an enforceable agreement, it has some teeth to it. The next section we have is the proposed amendment that came up last section, and we have a copy of that. And the proposed amendment was to restrict, to exempt the physicians. And of course, that did not pass last session. There was also a bill that came in Congress, which is called the Workforce Mobility Act. And I don't know if you guys are familiar with that, but it's very similar, in which it makes all non-compete agreements illegal. It is currently in the House of Representatives Committee on Health and Education, and it's pending right now. We don't know what's going to happen with that bill, but there's something similar in Congress. But that was what went last session.
Could I say a couple? I mean, what I found interesting about this bill was it says basically you can't hit a physician with a non-compete if they've been under a non-compete for 5 years. And that gets back to our concept of investment, right? They figured, look, you've got your return on investment. That physician has been there for 5 years with you. You've got you've got a return on all this training. You've given them all this thing, and so now we're going to take this off. I've kind of found that to be maybe that's going to be a fight, right? Is it going to be 5 years? Is it going to be 3 years? Is it going to be 2 years? Because a non-compete is only 2 years. This goes all the way up to 5 years. How do you determine that? But you could see. I think that this once kind of in my experience, once a bill starts hitting like this that has enough support to get out there, you're going to see it. You're going to see it over and over and over again. And so it's going to be, I think it's worthwhile to look at the actual wording and the actual time frames and see the next bill that comes up, is that number going to be lower? Or are they going to find some other way? It seems to me like they're kind of trying to bridge the gap here, right? Trying to say, we understand you as an employer have done a lot for them, but we also don't think you should be able to keep us forever. Yeah.
Who was opposing the tax? Hospital Association?
Who was the sponsor?
Who was in favor of it? Who was opposing?
Senator Bodie White was the author of the bill. A large hospital system, I believe, made sure it didn't pass.
Everybody's coughing all of a sudden. We can't figure out why. All right, briefly, we're going to be brief on this, the trends across the nation, because I think it'd be beneficial. I don't know what our time is, but I think it'd be beneficial for us to kind of give you some kind of rules of the road on non-competes and let you see some actual non-compete provisions. That might show you how ambiguous it is. But the trends across the nation, the bottom line is it's all state. It's state law, whether or not a non-compete is going to be passed. So you're in Pennsylvania, you can look at Pennsylvania state law. And there are states, I think we've looked at this, and it changes all the time. But there are states that say, generally, as to non-competes overall, not just dealing with physicians, California, Oklahoma, Rhode Island, North Dakota, they're generally hostile. So they either don't have it or they are trying to severely limit it. I found kind of interesting that in the physician space, specifically Delaware, Massachusetts, allowed non-competition agreements overall, but not against physicians. So they've actually carved it out like we carved out car salesmen. And Virginia, Tennessee, and Texas are more critical. Who knows what that means, but they're more critical of physician non-competes than other non-competes. So I think what you can take from it overall is that states have them. Most states have them. Most states say it's okay in connection with physicians, but some states start realizing physicians are a different animal and we should be treating them differently. Some say you can't enforce them at all against it. And I don't know if this is like, medical marijuana, whether we'll start seeing that everywhere, but there's certainly states that do it. And then overall, though, it's important again, and that's kind of a good segue maybe to the next thing. It's important again to understand what your non-compete agreement statute, I don't know if I said that right, but in Louisiana says, so you can see what to do. So in connection with, maybe we can go back one. So our general thoughts on non-compete. I think this is helpful. I find that most people stop, yawning when I speak about these things. And they are, one, again, I've already talked about reading it. That's just very important. Just read it. Make sure you understand what's going out there. You don't have to have a lawyer, but you have to read it. Every physician is smart. Every hospital administrator is smart. Just read it. Make sure you understand what it is. And now you've got the basics of what it has, right? It's got to have the scope of business. It's got to have the geography, and it's got to have a duration. And if it doesn't meet it exactly, it's not enforceable. That is pretty easy. You will get into some gray areas, as we will show you later. Second, wording is everything. And this is kind of leapfrogging on the first. It is a strict construction concept, right? For what Brent said. What did Brent say? It's not that non-competes are permissible. Make sure they're X, Y, and Z. It's they're not permissible. They're not allowed. The general rule, the first sentence of the statute is they are not allowed. The second sentence says, however, if we have these certain exceptions, sale of a business, employer-employee, they're okay, but you have to meet these three limitations: geography, duration, et cetera. So it's very important that they will strictly construe them. So the courts, and certainly courts do all sorts of things, but what they're supposed to do is they're supposed to go in there and say, look, I'm trying to find a way to knock this out. The general rule is these are not good. I've got to make sure it complies exactly with these exceptions before I allow it. So make sure that you look at the actual wording. This you'll love after all I just said. Courts apply statutes inconsistently, right? When you're talking about humans, you're talking about they may know Jed, who's coming before them as a non-compete, or they may know the lawyer on this side. I'm not saying it happens, but it happens, okay? So they're going to apply it inconsistently. So if you get into these gray areas where you're not sure, instead of saying every parish, what you say is every office, they can use that in a way that's not going to always be consistently applied. And they do it. They can look at the same. You could go across the country, across the state, and you could give the same non-compete to all these. You'd be amazed at how many courts enforce it, don't enforce it. It doesn't really necessarily matter. So if you're worried about it, don't get yourself in that situation. You need to make sure that it's set appropriately. Severability clauses, I think you all know what that is. It's just a clause that says if anything is not permissible within this contract, it's going to be carved out, and everything else is going to remain. Well, some courts apply that to the non-compete itself and say, look, if it doesn't meet the letter of the law, and you don't have a severability provision, I'm not going to cross out things that don't apply because you don't have it. Other courts say, I know Jimmy, I don't really care. There are courts out there who said there is no severability clause, and they still cross out parts of the statute. But if you have a severability clause, it generally allows you to do that. Amendment rules we've talked about, they generally are supposed to just strike through but not rewrite. So again, the wording is important. Buyout provisions, and maybe that's another thing that we've been talking about. So people say, what do you do if you join a huge health system that's all over the place? Well, what we're starting to see a lot more of is buyout provisions. It says, look, you're subject to this non-compete, but if you want to break it, you got to pay me X dollars. So sometimes that's where a lawyer comes in, or that's where if you are good negotiators comes in and says, your buyout is $2 million. That isn't a buyout provision. Let's be realistic. Let's be reasonable. You guys want some money off of that. If they want to break it, that's fine. But this isn't it. And a lot of people go, we didn't know Jim did that. They put it in. We're not sure. So a buyout provision is something, and you can ask for it. A lot of employers will put it in. They'll say, no, I get that. That makes sense. So will you have to take a hit? Yes. But you're completely out then. You can stay in Baton Rouge. Your kids can keep going to school. They can do those sorts of things. But obviously, I think the kind of the devil is in the details. Another thing that I think is important is oftentimes what I see is people come to me and they say, I love everything about my job, but look, they just asked me to sign this non-compete. And a non-compete, I guess everybody should understand this, it can be in an employment agreement. It can be its own separate agreement. It can be in a operating agreement. It can be in the company's operating agreement, and they try to make an employee, guided by this. So I've had success saying the employee didn't see that. We don't know about it. But my point is, if they ask you after you signed on the dotted line, right? You've got your agreement, you're employed, you're doing it, there's no non-compete, or the non-compete is to your liking, and they come back later and they say, just sign it. Sign this non-compete. Well, there's a lot of cases out there that say, you don't get that for free. This is a new contract. It's new consideration. So if they're going to make you sign it, it's not enforceable, arguably, if they're not giving you something, whether they're increasing your salary, whether they're increasing, your benefits, whatever they're doing, or sometimes we've had said there's no consideration for it, and they go, okay, well, never mind. We're good where we are. But technically, it's a new contract, so they should give you more consideration. And then maybe I'll let Brent talk about this, remedies. We see all sorts of and kind of to your point about about when you get in a fight with a big boy and like what you're going to do. And so some of these
have various remedies. You could have a liquidated damages clause which sets forth that if you breach, you are liable for X amount of damages. You could also have a mediation clause or an arbitration clause, and the difference between mediation and arbitration is mediation is not where you are required to do what the outcome is. So you would meet with a mediator, and the mediator would help you come to an agreed resolution. Arbitration is where you would have a binding resolution where you would meet with an arbitrator who's not a judge, and the arbitrator would make a decision. Arbitration can be a less expensive and a faster route that would resolve the dispute. You would turn over documents, and you would meet with the arbitrator, and usually in a conference room. You would have your lawyers, and he or she would make the decision, and that may be an alternative. And you might want to look at your agreement. You may or may not have an arbitration provision in your contract. So those are potential remedies that could be there as well.
And Brent does a lot of those, so I've sent people to Brent for those. So, but to your point, it's exactly that it's a different, it's potentially a cheaper way than going all the way through litigation. But if it's not binding arbitration, you'll end up in litigation potentially anyway. Yes.
Reese Newsom, Vice President. So one of the things that I wondered as a loophole, or as you mentioned, a remedy and a way out for physicians that have a non-compete clause, if they go and work for a federal clinic, a VA clinic, or a VA hospital, because it's federal, does that meet a loophole?
I used to think that was the case, and until recently, I had not seen that outlined in a non-compete agreement. But now I'm seeing that specifically mentioned in non-compete agreements, like you cannot go work for the VA, and in Orleans Parish, for instance, or East Baton Rouge Parish. So those agreements are right there. And from what I see from the law, I'll let the lawyers answer, it doesn't say anything about that in Louisiana law. So I assume that would be valid.
Yeah. This is where I could either tell you I know for sure and then be wrong on this tape, or I really don't, but I haven't seen that. I haven't seen that carved out, or I haven't seen people use that. Of course, I don't have a lot of clients, honestly, that have tried to do that, but I'm unaware. I may be wrong of a statute or something that allows you to do that, but I see your point, and I will say that it is not the case that we always litigate everything, and I think that people really misunderstand what I'll call a good lawyer does, because what I see a lot of times in connection with these contracts, a perfect example. So you'll get a resident who comes to you and says, I went to my Uncle Jimmy who does whatever type of law he does and is great at it, right? But he's a bulldog. And so what he did is he went in there and he told these people blah blah blah, but guess what? I really want this contract. I really want it. And I said, well, a litigator is great in his space, and I litigate stuff, great in his space, but that's the thing about joining a big firm or a medical practice if you're not on your own. The win is not a win if you take everybody off and then you have to work with these people, right? And so that's the one thing I can say. That's probably a great, and I'm glad that we got to this. I mean, my best example of that is we had a guy who said we represented the practice way back when. And the practice just got mad that this doctor kept asking, not in a mean way, but I don't like this clause. I don't like this clause. And finally, he just said, look, I don't care. He's either going to take it, he's lucky to have this job, and we're done. So that was relayed by some of our older partners in kind of a nice way. Well, fast forward 10 years. He accepted the job. That guy was in charge. The guy who said we're not talking to him was what? He wanted to retire kind of in his way. Like, I don't want to work as much. I don't want to whatever. What do you think that guy said to him? You're lucky to have this job. You're lucky. You should. So you're right. And I guess my point on all that is something like that. I think I could go to somebody and say, look, they're going to work for the government, or they're going to work for the VA hospital to help people. And you'd be surprised how many people say, no, I get it. I'll do it. It doesn't mean just because we have this clause, right, that it has to be enforced. At the end of the day, it has to be enforced by the person who put it out there, and we can go back and forth on those.
I failed to say I know 3 physicians personally who considered going to work for the VA, and they had this contract, and so it was a huge dissuasion.
Yeah. You want to go through some? What we thought we would do now is go through some examples. We'll actually show you the actual non-compete. Most of these are in the physician space. The actual non-compete that people were fighting over. And then we're going to ask you, or we're going to tell you, what were they fighting over? What part of it were they fighting over, and what did the court do? But do you have a question?
I was just going to make a comment on some of this Pittman St. Tammany. I don't know, but how many here would want to be represented in a medical legal case by Morris Bard? None. And the reason is he's in his group is usually the ones that are going to be suing physicians. They're not going to be on the side of physicians, but that's purely what they do. And unfortunately, both Mr. Hicks and Mr. Keaty are in firms that represent both sides of the picture. They represent physicians and they represent the hospitals. But when a physician gets in a conflict and goes, I guarantee you there's going to be, oh, we got a conflict of interest because we represent that hospital. It is a problem, and that exists in, we have problems in healthcare on that end, but y'all have problems on the legal end because physicians cannot get actual representation because a lot of times their attorney who might have given them advice on something, they will have to pull aside. And the hospitals do carry a heavy, heavy weight. Now, in 1985, I was the subject of a non-compete clause because I was an emergency physician, set up a trauma center over in Lake Charles, or helped set it up. And one of the groups that I was working for lost their contract. And every physician that was at that facility was not going to be allowed to work at that facility because they lost their contract. And that wasn't going to be anything where the hospital was at a problem. This was with an independent group. But the thing that we need to realize, hospitals do not practice medicine. It is a healthcare factory, and the physicians are actually workers in that factory, and they should be treated as in an employment concern, although we are professionals. To some degree, it has now become an employment concern. Back in 1990, it wasn't that, in 1987, it wasn't that big of a deal, but now it is. And as an employment concern, the hospitals can't have it both ways. They can't be telling physicians here, you're going to compete with us. Well, they are supposed to not be practicing medicine. And if the physician is going to be competing with them, then they're practicing medicine. Now, on the other hand, if you have a non-compete clause within a physician group, that, I think, is going to carry a little bit more weight. Unfortunately, it doesn't. The non-compete clause within physicians groups are the ones that are usually being thrown out. The hospital ones are being enforced. That is wrong, and that needs to be looked at. Now, the State Board of Medical Examiners in 1990, through the Louisiana State Medical Society and recommendations, they came out with the corporate practice of medicine guidelines. Nothing has been enforced on that. And it really needs to be, but it's difficult to do because of the political infrastructure that exists here in the state of Louisiana. And 10 years ago, I brought forward a resolution through this body, and it was passed, and the State Board of Medical Examiners actually put out a position statement on the unauthorized corporate practice of medicine through unlicensed personnel. And unfortunately, that is going rampant, and because it's a cost matter. Physicians, assistants, and nurse practitioners are going to be cheaper. And a lot of those are being included in these non-compete clauses. Non-compete clauses are a double-edged sword. The problem is, it's going to be who's wielding the sword that's going to win, and the physician's going to be at the bottom of the rung unless they have support from medical society and the State Board of Medical Examiners and have attorneys that are willing to stand up for them to fight against the hospitals. But it's difficult. I just wanted to make those comments. And one other thing, and most of y'all here know, I was the deep cover consultant for the Justice Department that took down Columbia HCA. and my identity was disclosed at the settlement agreement. And after my identity was disclosed, there were two physicians that I charged with negligent homicide and the commission of a first-class felony insurance fraud. They actually, through the commission of this fraud, caused the death of a patient.
Right.
And it occurred not through the Columbia HCA investigation. I was helping the Justice Department defend a VA hospital on a medical malpractice case, but the patient actually died at HCA. Both of those physicians contacted me after my identity was disclosed and said the same thing. Please forgive us. The administrator of the hospital told us we had to do this, and we had wives and families to think about. I said, no, you had a patient to think about. And now these non-compete clauses are coming along, and they're making it difficult for the physicians to concentrate on their patients because they have a big nut to crack on what they paid through medical school and residency.
Right.
And then all of a sudden, they don't want to lose their job, and it is a problem. And
Gotcha.
there needs to be some control in that, and needs to be recognition that the State Board of Medical Examiners needs to look at the corporate practice of medicine a lot closer.
Right.
Thank you.
I appreciate that. People that are passionate about their position. Corporate practice of medicine is a whole nother hour and a half. So we'll get into that at some point. Let us real quickly, I don't think we have much time. I do appreciate the comment. Let's look at this non-compete provision. This is paradigm, I should say. Relatively recent. Physician is not allowed to engage in the practice of medicine or render any medical services to any business similar to those services provided by employer located in the following parishes with certain exceptions, and the list of parishes shall be expanded if the employer opens new offices in additional locations in which this non-compete will apply. So this is where I ask, and nobody ever raised their hand, but what do you think the issue was here? It's scope, I'll give you it's scope of business, or it's geography, or it's duration. Scope of business, right? So what this says is everybody would agree, and this is the difference with physician non-competes, that unlike a car salesman, you just know they're selling cars, or a computer salesman, you know they're selling computers. With physicians, they are in a specialty or a subspecialty, right? So you can't take a physician and say he can't engage in the practice of medicine. There may be a whole host of things that he can engage in that are different than what he was doing for that employer, or different than what that employer was doing. So what did the employer say? It said, well, yeah, I get that. Practice of medicine, that is very broad, but it also says they can't render any medical services to any business similar to those services provided by employer. And the court said, great, what services do you provide? And the employer said, this. And he goes, where's that in the contract? I said, can't see it. I said, sorry. Okay? So even though you would think that gets you there, right? Render any medical services to any business similar. The court is saying this is strict construction. We're supposed to deny these unless it's perfect. You're supposed to tell me what your scope of business is. This doesn't do it. Practice of medicine, way too broad. Medical services, any business similar, we have no idea what that is. And more importantly, the physician who signed this didn't see that in the document. So we're not going to hold him to it. So, unenforceable. Yeah, go ahead.
We signed a non-compete agreement with the House of Delegates, and I think they have this room after 11:50 because they need to prepare it for the next meeting.
Okay.
So,
all right.
We're out of time.
We will provide the presentation online at the LSMS website under resources after this is over, if anybody's interested in that. And please take your things when you leave the room because we have to reset it for House of Delegates. Thank y'all very much.